So last week I was supposed to have 4 speaking engagements, and also the fact that it was also World IP Day, so it was going to be like really busy for me because I had to brush up on my knowledge and stuff like that. But one of my sessions got cancelled last minute, and I was, should I say, excited? But so this is part one of my presentation from last week, and this is strictly for those in the entertainment industry. So if you're an artist or a performer or you do anything in the music industry, this episode is for you. I think I may have recorded something for creatives, but this is more or less like intellectual property guide for artists, musicians, singers, performers, what they really need to know about intellectual property and the music law. So stay tuned, guys.
Hey guys. Hi guys. Hey guys. Hey.
This is not your average podcast, trust me. This is IPSERIES, where you learn to protect and safeguard all your intellectual property so you can make a career of what you love. Join me, Rita Amri Chinda, as we discuss all things intellectual property from the world of fashion, film, media, entertainment, dispute resolution, and even technology. Welcome. As an artist, a singer, musician, a producer, if you still do not understand the basics when it comes to intangible assets as it relates to intellectual property, what is eligible, what can be protected under the Nigerian law, and also music law governance in terms of the business angle of the entertainment and creative industry, then you are on a long team. Um, you need to understand that the relevant intellectual property that would apply to you, um, based on the categories I listed, musicians, singers, performers, is first copyright law before you start thinking of things like trademark and then other related laws or legal frameworks such as immigration law, health law, etc., etc. But I'm going to delve into that at some point. Now, copyright eligible works as provided for under Nigerian law will be musical work, sound recording, and then performance right. Now, copyright basically will grant you um, a bundle of exclusive rights that you can monetize. Now, you already know that your musical works and sound recording, irrespective of the quality, already enjoys protection under the Nigerian Copyright Act as long as it is in a fixed medium or a tangible format. Now, your musical work will include musical compositions, lyrics, while sound recording will basically focus on the master records, while performance would be either the dance or the song that was acted out. If you ended up performing to like a large crowd of persons or audience who had to pay money to come see you, that's like the elements of this type of eligible work. And finally, it must be original. Even though a sub-original work can be created which will now enjoy a separate form of intellectual property rights, a separate form of copyright as well. But first, the initial creation must be original. Now we're done explaining what IP is to a creative. We'll look at the bundle of exclusive right which they can monetize. First, you have the right to reproduce, right to publish it to the public, right to perform it to the public, right to make any um audiovisual work or record in respect of that work to distribute it to the public for commercial purpose, either through sale or transfer of ownership, as long as that work is not subject to distribution that has already been authorized by the artist. You can broadcast it. You can make it available to the public by wire or wireless means that enables them to access it from anywhere they are at the time they so choose to access the work. Someone can also make, you have the right to make an adaptation of your work, to do a translation of the work, which provides that in an event where a performer gives his consent that his performance should be included in a visual or audiovisual work, section 65, which basically talks about presumption of consent, stating that a performer will be deemed to have given his consent to the broadcasting of a work um, if also is going to apply to any modification of any kind if the performance um, or reproduction of that performance is used without his consent as provided under section 63, which basically lists out the exclusive rights that they get to enjoy and control how people can use their performance. Now, if you're going to be relying on that, you have to show that the performance was used without the consent of the performer to demonstrate, by demonstrating that you did that in good faith of a radio or a television receiver, or recording your playback equipment to clients by a dealer, or that the reproduction was a short extract from an object of the performance rights whereby you're reporting current events, say for news publications, or maybe you are carrying out a research or you're undergoing a private study in relation to the performance rights, where it has been kept in a publicly accessible library or educational establishment, museums or archive, or in the premise of an institution. Or you can say that the reproduction was done for the benefit of those with disability, because we currently have, I think it's section 28, let me confirm. So it's section 26, not 28, like I stated. So people with disability now have, they can reproduce a performance work for them as long as it's for non-commercial purpose to the extent required by the disability, and then you're making an ephemeral recording of the object of the performance right as a broadcasting organization, with your own facility and for your own broadcast, as long as that recording will be preserved for a period of no more than 30 days, and you will not have to erase it after you have used it for broadcasting purpose. Um, if the recording of an exceptional documentary character may be transferred to designated archive for preservation, such as like documentaries about Michael Jackson, XYZ, stuff like that. So these are like the exclusive right that the owner of a musical work enjoys, the owner of a sound recording will enjoy, and the owner of a performance right would enjoy in Nigeria. And there used to be a period when it was so common to see things like an author is going to transfer, or the creator of the work is going to transfer both his economic and moral rights in contract. But I would say kudos to those who have been creating awareness in terms of what should be in the contract, and advising creators to have their own independent legal advisor or lawyer. You've seen less and less of that, but now um, under the Copyright Act, we have provisions for moral right, which provides that an author has the right to first claim authorship of his work, especially when it's in connection with either of the eligible workers provided on the act, from musical work to sound recording. And then there's also moral right provision for performance right under section 66, which provides that a performer has they have the right to be identified as the performer in connection of their work, to object or prevent any form of distortion, mutilation, and modification of their work. They also have the right, um, so they cannot transfer that right during the time they are alive, and upon their death, it shall be transferred by testimony disposition or by operation of law, which is also similar to section 14, which focuses on musical and sound recording. It also gives the author the right to object to a work being falsely attributed to them as authors. And the term of duration, it shall last for the lifeline of the musical work or sound recording work, or the performance in question. So, what moral right does for you as a performer or a musician or a producer is that you can prevent anyone from using your work to do anything that would cause harm to your reputation. One of the instances I gave to my artists when I was talking to them was how if you maybe created a Christian song, or the genre you basically sing is someone decides to use it for something immoral, so they're going to sink it into, say, a porn scene, and you're like, no, 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 that can't be done, stuff like that. You still have the right to object to how the work could be used, because you don't want anyone to um damage your reputation and the hard work you've put in to build a brand over the years. Interestingly, there is also a provision where um, the law states that um, in an event, notwithstanding any assignment or sale of an original work, an author of a musical composition shall have an inalienable right to a share in the proceeds of any sale of that work by music auction or through a dealer, subsequent to the first transfer by the author. So is this section only applies to original musical works. So if as an artist you're looking to commercialize or exploit your work, make money from it, you have to do a transfer, either by an assignment or by selling it. You are entitled to share in the proceed of that sale as long as the work is original. So the very first copy has not been um, remixed or a cover being created or something. This will also apply to the people. This will apply to the people that eventually get to inherit your work in the event where you die. So, for instance, we've had the likes of Dagreen in Nigeria, the likes of Fela, and currently Mobad. Um, so, in these circumstances, if an assignment was given, someone has assigned um the musical work or the sound recording of any of these artists, their heirs and successors are entitled to share in the proceed of that sale. Now, the Nigerian Copyright Commission is supposed to come out with a regulation that will guide such sale, but I've not seen any that has been published at the moment. Then you also need to know that the moment your work has been created, copyright will commence when that work has been created. So, for the moment you put pen to paper, you start writing your lyrics, start working on the beats, start working on your performance, that work enjoys copyright protection. So, the law will recognize that person as the first author. Now, for musical work, they last for 70 years after the end of the year in which the author has died. So for life or 70 years after, while sound recording will last 50 years after the end of the year in which the recording was first made available to the public with the consent of the author, or 50 years after the work was created if it was not made available to the public. And then for copyright work, as it applies to anonymous work or pseudonymous work. So whether it's a literary, especially for literary work, it will last for 70 years after the year in which the work was first made available to the public with the consent of the author, or 70 years after the work was created if it was not made available to the public within that time, as long as when the author became known, the duration of the copyright shall start counting. And then the event of where you have multiple authors or joint authors, is it will last the lifeline of the authors up until when the last person dies. I don't know if any of us have seen this publication where I can't remember the artist now, but there's this band where they're like, okay, they just found out that they created this song or something like that. Can't remember the true story now. But this is where anonymous or pseudonymous work, musical work, will come into play. And for performers as well, your work will last for a period of 50 years after it was the lifeline, um, plus 50 years after when the work was first, the performance was first fixed or created. So next we'll be looking at special exception in respect of sound recording of musical work, and section 27 provides that the copyright in a musical work will not be infringed. So infringement basically is when someone uses your eligible copyright without your consent, permission, or authorization for profit for commercial purpose without your consent. Now, in the event where that happens, it's not for profit now. The recording of or the adaptation must have been previously made or imported into or otherwise made available in Nigeria for the purpose of retail with the consent or license of the owner. So this is when this act now will not be said to have been to infringe on the person's work. Then before making the recording, you gave notice in the prescribed manner. You gave notice of your intention to record to the owner of the copyright and the relevant approved collective management organization had granted you the permission to go ahead and do the recording. If you also pay the owner of the copyright or the relevant approved collective management organization or CMO a royalty of an amount equal to the percentage of the ordinary retail selling price of the record calculated in accordance with the regulation by the commission, which is the Nigerian Copyright Commission, um, the where a recording also comprises of two or more musical work, um, the recording in the copyright would exist and the of the copyright work would be two separate persons. So the royalty will be shared accordingly to the parties in the manner that they have agreed, or in the event that they sign an agreement, which is like the right thing to do. So whatever was agreed is how the royalty will be shared, and this will also be in line with the rules of the relevant collective management organization or the copyright regulation. Also, where a recording involves a performance of a musical work or an adaptation of a musical work, whereby the words um, are being sung or spoken, and where no copyrights exist in a literary work or where copyright subsidies conditions specified in subsection 1, which is that the recording of the work was previously made in Nigeria, or they are giving notice to the owner or the relevant CMO, or you've paid money, then the making of that recording will also not be said to be an infringement in the literary work. But we're not focusing on literary work now, but mostly musical work. Also, if there's an adaptation, it will be taking that adaptation is similar to an adaptation that was contained in the previous record. And if the two adaptations are different substantially in the treatment of the work, in respect of the style, or there's just a difference, then um, it will still not be considered to be an infringement, and then the Copyright Commission has the power to now make regulation relating to this special exception as relates to musical work in sound recording. Now, remember I stated that copyright exists from the moment your work is created, and under the law, the person that creates that work, um, the first person who created it is regarded to be the author of that work. Now, in the absence of an agreement, which is why it's important that you sign an agreement, in the absence of an agreement, if the work was created under a contract for service in the instance of a producer, um, that's a producer or a record label or music agency, then under the law, that work will belong to the producer or the record label. Now, we're going to also talk about um, ownership of work in a collective work. Now, basically, um, copyright in a collective work would be or would rest, or the person who came up with the initiative or directive will be regarded as the owner of the work, and they all have the right to exploit the work independent of the rights in the collective work. Now, ways that you can monetize assignment and license, and under chapter 4 of the Constitution of the Federal Republic of Nigeria, please, if you haven't read it, please read. Copyright is said or considered to be a movable property and shall be transferred by way of an assignment or testimony deposition or operation of law. Now, what the law says is that an assignment or a testimony deposition has limited rights. It can only be limited to some of the rights or bundle of exclusive rights that you enjoyed, whereby the owner of that copyright will give you um, a part of that right. It could be the right to publish or to distribute their work for a period of time and would apply to a specific country, for instance, Nigeria or any other geographical area. An assignment of a copyright or an exclusive license is also controlled by the copyright owner. So a license could either be exclusive, which is between party A and party B, or it could be non-exclusive between party A and multiple other parties. So what the law says is that an exclusive license must be in writing, else it will not have any effect. Whereas for a non-exclusive license, it can be inferred through conduct of the owner of the copyright. It may be written, may be oral, but best have it in writing. Um, an assignment or license granted by one copyright owner in the event of joint authorship shall have effect as if it was granted by the co-author or owner of the work, subject to any agreement between them, and any fee or royalty agreed will be shared equally between parties. Now, for co-owners of a work, say you have a feature that is parties will share joint interest in the whole or part of the copyright, which in this case could be musical work, sound recording, or performance. And one other thing again that people fail to understand, that is the fact that I transferred my work to you does not mean that I have transferred. So I've transferred some of my bundle of rights to you. That doesn't mean I have transferred my copyright or I've granted you a license for the exploitation of the work in perpetuity. No, unless it has been expressed in an agreement, the owner of a copyright that has transferred his rights or granted a license for the commercialization and exploitation, either through an assignment or licensing, um, will not be said to have transferred ownership of the musical work or the sound recording or the performance. I hope that is clear. Finally, an assignment or license or testamentary deposition, which is like a will, may be granted or made in respect of a future work or an existing work in which copyright does not subsist, as long as you're not permitted to transfer the rights in all the future work of an artist. For instance, especially now when we're dealing with issues related to artificial intelligence. Last year or 2 years ago, we were talking about NFTs and the metaverse. Um, right now, basically large language models, artificial intelligence, there's a lot of pushback. I saw a conversation on X where a particular NFT company is who had opted for like a Creative Commons license is now telling people that Wait, let me look for that tweet. So basically, they are saying you can now revoke your Creative Commons license, which, if you read the Creative Commons license terms of use, that cannot be revoked. So there's a lot of issues and technicality related to um, what happens when you get a license to a particular token on an assignment, or a license to the ad that was tied to the token. Um, what then happens to the new license that this particular platform is offering at the end of the day? These are some of the issues that the law was trying to cure, in terms of talking about future work of an artist. So next, I will be looking at what would amount to an infringement. An infringement, basically, like I previously stated, is when you exercise any of the exclusive rights or acts that the law has granted to a copyright owner. For instance, you have allowed a public entertainment place or a public business place to be used for public performance of a creative work, an artist's work, or a performance work. That performance will constitute an infringement unless the person permitting the place to be used will be claiming that they were not aware and that they had no reasonable ground to suspect that the performance would constitute an infringement. If you have in your possession plates, master tapes, machines, equipment for the sole purpose of making infringing copies, in the days when we used to have a lot of CD being um, produced, I bought a couple. Now I know better. So, you know, now we're dealing with streaming, illegal downloading, etc. If you also um, permit the reproduction of your work within your premises, if you import into Nigeria any copy of an infringing musical work, um, if you also broadcast a substantial part of a live performance, so you go for a Davido's performance, a Johnny Dree, so Johnny Dree has a performance coming up in Canada, then you start live, you start broadcasting or live streaming their performance. Um, you're basically infringing on their performance right, because they are the ones that have the right to publish and broadcast and distribute to the public, and you're doing that without their consent. That's an infringement. Now if you import um recording of a performance work without their consent, if you're not using it for private use or not domestic use, as an infringement. If you sell, let for hire, distribute, display, sell, record a recording of a performance work, as an infringement. So know all of these things, nuances, and try to avoid them. Syncing or using someone's work without their consent, as long as you're monetizing it. There's a case I had reviewed because it's not been published. I can't mention it. Still waiting for it to get published. If it doesn't, but any of these acts, whether under Section 31 or Section 36 of the Copyright Act, any of these is an infringement, and you could have um, a civil case or a criminal case depending on how it goes. Now, what are the remedies available? You have damages, injunction, account of profits. So you made money for it. Let's do the IP valuation, get it done with, and move on. You can also have Take note also that in an infringement of work, physical or sound recording, whether it's civil or criminal, especially when the work has been recorded with registered rather with the Nigerian Copyright Commission, it will be assumed that copyright exists in that work, which is the subject matter of the alleged infringement. Then the name of the person appearing on the work purported to be the name of the author. That the name appearing on the work purporting to be that of the publisher or producer of the work. Where the author is dead, that the work is an original work, that it was published or produced at the place or the date appearing on the work, which is basically like the copyright notice you see. Now, the criminal aspect, criminal liability, anybody who sells, make for hire, imports, has in his possession, a fine of 10,000, small money. For, okay, 10,000 for every copy dealt with in contravention of this section or imprisonment for a term of at least 5 years or both. So 10,000 times 5,000 copies or more than a money. Oh. And then anybody who sells or has in lets for hire, has in his possession, any infringing copy distributes, or has a business that has an infringing work or has in his possession, 10,000 for every copy, and then for a term of 3 years. Um, if you can prove to the satisfaction of the court that you did not know that the copy was an infringing one, then you will not be guilty. If any person without the consent of the owner distributes to the public for commercial purpose, they are liable to commission to a fine of at least 1,000 naira for every copy dealt, and then imprisonment for a term of 3 years or both. Um, the court before which any proceeding is taken for an offence under section 1, 2, 3, 2 and 4, which is what I just read, the court may order that the infringing copies of the work, master stays, machine, equipment be destroyed or surrendered to the owner of the copyright. Where do authors make money from? They make money from public performance on radio, televisions, download, streaming, online live performances, concerts, um, shops, or anywhere their musical work or sound recording is being played or heard in public. Income from mechanical licenses when recordings are distributed. Mechanical licenses are licenses that are issued by authors or publishers to producers, allowing them to legally exploit their recording and audiovisual production containing the work. Income from mechanical license would include visual downloads, audiovisual downloads, streaming via the internet, or as ringtones, ringback tones, or real tones. Income from synchronization licenses when the work is synced to visual images, video or film, or adverts, commercial, video games, podcasts. Income from sale of printed sheet music, and then income from home copy, levies. While performers will make money from their live performances in front of audiences as festivals, concerts, venue, clubs, public places, or private events. Income from master reuse when the recording is synced to visual images, video, or film. Income from public performance when the recording is played on the radio or television or in public, such as hairdressing salons, hotels, clubs. Um, you can also make income from royalties when a producer or record company or label sells a fixed performance recording to the public. Um, Income from royalties when a producer sells a digital recording via the internet as a download, by streaming, or as a mobile phone ringtone, real tone, or ringback tones. It's very important that authors, performance artists, manager make sure that they're on the receiving end of all the incomes that I've listed. I want to talk about another interesting thing, which was one of the new innovations of the Copyright Act. I know I've done like an extensive review of the Copyright Act, but just to mention, especially now when we're dealing with online related infringements, under the new act, you can explore using technological protection measures, which is basically using a form of technology or device used to prevent infringement of your copyright or related rights, such as performance. So, if you've gone through these measures to protect your work and someone still goes ahead to bypass these measures you've put in place by either manufacturing, importing, or selling that device or technology, or monetizing it, distributing it, then they have infringed on your work and you can use the law. So, circumventing the technological measures controls access to a particular portion of the program for the sole purpose of identifying and analyzing the elements of the work in question. Um, you can also explore what is called the rights management information. So, which means any information that identifies a copyrighted work or other subject matter, the owner, the author, the rights, including information about the terms and conditions and of its use, or any number or code that represents such informations attached to or appearing in connection of the work. You can also explore for manual infringement, restriction, or importation, whereby you go through the Nigerian Copyright Commission, who will then give notice to the Director General um, or the Controller General of Customs to ensure that any infringing work brought into Nigeria will be impounded. Then we have the take down proceedings, notice to take down an infringing work, where you have to liaise with the internet service providers rather, and there's a timeline for all of this. You give a notice in writing, include your information. They will write to the infringer after they've temporarily taken down the work, and if they don't get your own counter notice in 7 days. It will be put back. But for someone who is considered to be like a multiple infringer, it will be taken down. They also have provision for blocking access to online content. The commission may directly or with the assistance of any other person block or disable access to any content or link or website hosted on a system or network that they believe to infringe a copyright work. Now, the internet service providers also have limitations to their liability, whereby um, they have to be neutral automatic. The service providers who do not take an active role or intervene or participate um, in ensuring that an infringing work is taken down, you can now rely on the powers of the court or any other administrative authority, such as the NCC, to direct that the service provider terminate or prevent further infringement or an infringement that has already occurred. Other available remedies will be issuing cease and desist letters, notices to the infringer, giving them a timeline to take down the infringing content. You can also explore going to court to enforce your right. Um, there's also which provides that any disputes that arise from the exercise of a right um, under the Act may be subject to arbitration. Arbitration is a form of alternative dispute resolution mechanism where it may be resolved by means agreed by parties. So parties can choose to arbitrate or mediate as the case may be. So I previously mentioned cease and desist with a timeline. Um, in any proceeding for infringement of copyright, no order shall be made which requires or completed reading, etc. Then there's also section 90, which talks about section 90. Please hold on. Yeah, which talks about how the Copyright Commission can constitute a dispute resolution panel to resolve disputes around payment of royalties, term of license, or any other matter that they deem fit to carry out. Now, where this proceeding has commenced and the member of the panel is unable to continue as a member, the panel shall remain constituted for the purpose of proceeding, which means it can be a two-man panel, as the case may be. Um, and anybody who is not satisfied with the decision of the dispute resolution panel can appeal to the court for a review of that decision. Now, remember, I stated that there are other areas to note as an artist or entertainer or in the music industry. But before I get to that, let me just list a couple of relevant agreements such as split sheets, collaboration agreement, producers agreement, sync licensing assignments to CMOs. I think there's this case between Koson and the Cross River states in relation to the December festival. You also have featured artist agreement, publishing. There are different type of publishings as well. There's also different type of licensing. I also found out that we have, though not within Nigeria, but under the UK law, there's something called the orphan licensing agreement, where if you cannot find out who owns the work, you can reach out to the intellectual property office, get their license to use a musical work. There's also the 360-degree agreement, sample clearance. That's it for contracts. Then other areas to note: trademark. Trademark will basically apply to words, phrases, slogans, colors that an artist uses to differentiate itself in the market. You must make sure that the name of an artist is distinctive enough and capable of distinguishing between Techno and Kiss Daniel. Remember, Kiss Daniel had the case Kiss KISS and now Kiss KIZZ. Um, Amongst all the IPs, copyright grants you automatic protection, whereas for trademark, there are two ways you can protect yourself, but the best way is to register it with the trademark registry. Timeline for registration 18 months to 24 months from search to certification. There's also the mandatory 2 months opposition that you must go through, whereby the registry will put out a notification publication in the journal stating that this person wants to register their mark, and the opposers and anyone that wants to oppose can reach out to the registry and go through the whole process of trademark opposition. Um, so we also have trying to remember this artist, can't remember, but then trademark registration for your name. If you also want to, yeah, so likes of Rihanna who have used their family names for businesses. Taylor Swift has a lot of trademark restriction in relation to her musical works as well. um Ariana Grande has merchandise. A lot of them take advantage of merchandise. I think Beyonce just recently released Sacred, which is like a hairline for naturals. Fucking expensive. Rihanna has Fenty. She also goes into collaborations with other brands, like there's the Fenty Puma collection. Um, Ariana Grande, I keep mentioning her because I love her and I love her song. She has a perfume line. She has a couple of things. Who else? Katy Perry as well. Beyonce has a perf. She does, yeah, she does. Clothing line. There was this dispute around Shakira and some Nigerian guy in the UK and stuff like that. Then image rights, where you can use your name, image, likeness for sponsorship deals, brand ambassador deals, um, etc. to generate revenue. There's also competition law, depending on your jurisdiction. There's the employment law where you're dealing with people you're working with or your team. There's contract law, which is like the contracts I mentioned, offer and acceptance, very important. There's defamation, where people make allegations against you. We currently have a dispute about two popular Nigerian Christian artists. Some allegations were made against them, so now they are suing for defamation. There's immigration, especially for artists who tour, go on live tour, festivals, etc. Like for Johnny Drill and the rest who are going to Canada, they have to go through immigration and stuff like that. Then health and safety within that jurisdiction, licensing, and all of that. So this is like a brief rundown of an IP guide for artists and music law governance. Know that when a record label signs you in, they're giving you an advance and you're supposed to make money for them. We don't want to keep seeing conversations on, oh, this person do this. I mean, the internet has been in a frenzy over the last couple of days because of the post by Wizkid and how every other artist is being dragged in the video. I saw one by Flavor um last night or 2 nights ago where he was saying something along the lines of, we were born yesterday. If you don't know, I'm in a league of my own. I know they in competition with anybody. Where you want start hit songs, live performance, find me for different genres. I did not put down. Omo, please oh. Before you dive into all these kind of fights and conversation, ensure that you understand author ownership, who owns words. If you're an independent artist, if you're giving out your publishing rights, if you're getting advance for distribution or publishing deals, ensure that you have your lawyer to vet for you. Don't be too greedy and you end up selling out yourself. Learn the business of law. Really recommend Mr. Payemi's book on music commerce in Africa. Um, Follow Godwin Tom and register for his music business academy class if you're an artist. Save for it. Like I was telling the artists when I was talking to them, they're like, "Oh, legal is expensive." I was like, "You guys basically don't save for legal. You just focus on recording and all of those things. But you have to save for all of this. Ensure you're investing in yourself. Ensure that before you get signed, you understand what you really want out of that relationship so you don't get taken advantage of. But yeah, I think that sums up the whole conversation on the guide on IP. Thank you for listening to IP Series Podcast. If you enjoyed this episode, please subscribe, rate, and review us on your favorite podcast platform. Don't forget to share it with your friends, family, and colleagues. You can also follow us on Instagram at IP Series with Esmeraldo ESQ or Twitter at IP Series 1 or send us an email to ipseriesinfo@gmail.com. Until next time, stay tuned and stay informed.